Podcasting isn't just about talking, it's about growing, engaging, and monetizing, and that's where Podcast One Pro comes in. Whether you're an independent creator or a major brand, Podcast One Pro gives you the tools you need to take your podcast to the next level. We're talking about premium hosting, advanced analytics, dynamic ad integration, and expert distribution, all designed to maximize your reach and revenue. Plus, with access to Podcast One's industry-leading network, you'll be connected to top-tier advertisers and a massive audience. It's time to go pro and turn your passion into profit. Visit podcastonepro.com to get started today. Podcast One Pro, the power behind the podcast.
I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Welcome back to the Prosecutors Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my finally showered co-host, Brett.
It's true, Alice. I did indeed take a shower today. It was a momentous occasion.
Let's just say, guys, you know how sometimes they're like, oh, you have a face for podcasting, for radio. Sometimes it is a gift that you just hear Brett's soothing Southern voice and don't smell him, because since he's become fun-employed, I don't know that he's taken that many showers.
I mean, you know, if you're really not going out into the world, what's the point, right? Don't take too many showers. It dries your skin out, ruins your hair, my luxurious hair. But yes, people started noticing in the chat that I was wearing the same clothes.
Which says something, because they can't smell you. It was just based on looks alone. But
Very
here's
observant.
the thing. Perhaps,
great witnesses.
Perhaps the reason, great witnesses, no kidding. Perhaps Brett has not had time to shower because he's following all the latest legal developments to make sure he brings it for you. And of course, today we bring one of the saddest, and that is about Harmony Montgomery's murder.
Yeah, this is one of those cases that it's awful and it's tragic. It's horrific. It's infuriating. It's disturbing. We thought it was over because... And I don't normally say this about murders because I think we tend to overuse it. But the monster that murdered her had been convicted of her murder, had been sent away essentially for the rest of his life. But as things sometimes happen, and as unfortunately we've seen happen multiple times this year, just because you have a trial and just because you're convicted does not necessarily mean that is the end. And this case went up to the New Hampshire Supreme Court, and in a decision that I think was shocking to most people, and is a reminder that you never know what an appellate court's going to do. Adam Montgomery, Harmony Montgomery's father, who brutally murdered her, 5-year-old girl, beautiful little girl, his murder conviction was overturned by the New Hampshire Supreme Court, and obviously a lot of people have asked, how could this happen? Why did this happen? And that's what we're here for, is to explain why things like this do occur.
So even if you haven't heard of Harmony's case, absolutely devastating to die at the hands of your own father. Adam Montgomery is her father. He was convicted of her murder, but his murder conviction in the death of his daughter Harmony was overturned by the New Hampshire Supreme Court. So in 2024, Montgomery was sentenced to 45 years to life for the murder of his daughter, who was 5 years old at the time of her murder. Her body has never been found. And this whole case is a nightmare. So Harmony's mother was not with her father. They were separated. And she reported she last saw her daughter in April of 2019. And when she tried to contact Adam about her, he never responded. And she was trying to find out where she was, trying to contact Adam. And finally, with no answer from Adam, she reported Harmony missing to the police in 2021, 2 years after the last time she saw her daughter.
And look, there's been a lot of ink spilled on this case, on the failures of various services, child protective services, People have questioned, why did it take so long? You have to understand, and I'm not making excuses, but very broken family in some real times, as we're going to see. A very difficult situation. We're not going to go into all the details, but I do think there were some failures definitely on various entities' parts to protect this young girl from her own father. And as you're going to see as we get into the details of this case, we're not going to dwell on them, but I think it's important to at least know what this poor girl went through in the last year of her life and probably for her entire life. So her mother last sees her daughter in April of 2019. Harmony lived with Adam and his wife, her stepmother, Kayla, in New Hampshire. I believe they lived with Adam's grandparents. His family was all around this area. In July 2019, Adam beat Harmony so severely that he left her with a black eye. Multiple people saw this. He freely admitted that he did it. And I think it's safe to say he was proud of it. This was his way of disciplining his 5-year-old. He would punch her in the head and in the face. So by November, the family has been evicted from their home, and they are now living in Adam's car. It's an incredibly difficult situation. Harmony had been potty trained, but given in between her father beating her and the situation where she's living in a car in November in New Hampshire, incredibly difficult situation for a little girl to go through. I mean, you wish they had just driven to a hospital and dropped her off. You know, if you don't want to deal with her, give her to someone else. But she starts having potty issues. She starts having accidents. And every time she has an accident, Adam beats her. And he punches her, much like he did in July of 2019. By December, Adam has beaten her to death. She has one of these accidents. He punches her multiple times. At some point, he hits her and he feels something break inside of her. He sort of freaks out and realizes he's hurt her, pulls over to the side of the road. She's dead. He then puts her in the trunk of his car. He moves her around. He puts her in the ceiling vent of a homeless shelter. He later puts her in a walk-in freezer at a restaurant where he worked. He then takes her body to a bathtub in an apartment they're renting, essentially thaws her out, goes to the store, buys a bunch of tools, and dismembers her in the bathtub. And, you know, once again, why do I support the death penalty? For people like this. This man should be executed. Unfortunately, the crime he's charged with, that's not even on the table. It should be. I mean, this man should not live. He should not be supported by the state. He should not see another day. But regardless of that, he is eventually arrested for her brutal murder and the horrible things he did afterwards, and tried and convicted. But unfortunately, that conviction doesn't stand.
Really one of the most horrendous fact patterns I've ever heard because of the way he treats her poor, lifeless body after the fact. You know, we've covered some horrendous child murders where adults, sometimes the parents, who may or may not have anything to do with it, still continue to treat the lifeless body of a child with intense care because it's incredibly life-altering to see a lifeless child. It's not as it should be, right? We hear about this in the police who find the boys in West Memphis 3, how it changes you forever because seeing young children lifeless is horrendous. And not to be affected by it, but to then do such horrendous things to her, to move her body around to conceal it, then to dismember it, is a different type of monster than I think even the worst that we've seen. So first, let's get to the good news, if there can ever be any in this horrendous murder of Harmony. And it's hard to even dwell on the good news because we know what's going to happen, which is the vacation of his conviction. So in addition to the sentence for murdering his daughter, other related charges were not overturned. For these charges, Montgomery received 43 and a half years in prison. So this is separate from the murder charge. These stick. These convictions are not overturned. So he's not actually going anywhere. He's staying in prison. That is the actually good news. He's not getting released tomorrow. This monster of a man is not walking the streets and won't be for the rest of his life.
And, you know, I mean, I'm pretty opposed to vigilante justice and prison justice, but I wish someone would just beat him to death in prison, just like he did his daughter. That's my preference for this guy. I mean, he's an absolute monster. And you know what? I get it. Everybody has a right to appeal. I mean, that's your constitutional right. But you would think at some point you would take some responsibility for what you did. You know, He admits to dismembering her body. He admits to hiding her body. We're going to talk about that. But he never took anybody to her body. He never gave that body to her mother so that she could be buried, so that at least that piece could be had. I mean, just the lowest of the low. In any event, so what happened in this case? Why is it that his murder conviction was overturned? Well, as we said, he was charged with multiple counts, and he was convicted of them all. And those other counts included 43.5 years in prison. He's charged with second-degree murder because it's not a premeditated murder. New Hampshire doesn't have death penalty, but that's why it wouldn't even be on the table, because for some reason, we only have death penalty for premeditated murder. So second-degree murder, second-degree assault. I'd like to know what first-degree assault is, but in any event, this is for striking her in July when he gave her that black eye. Falsifying physical evidence and witness tampering, and he's also charged with abuse of a corpse. Convicted of all that. And in fact, to most of these charges, his defense strategy was, yes, I tampered with evidence. Yes, I tampered with witnesses. Yes, I dismembered the body. But I only did that to protect the real murderer of my 5-year-old daughter, my wife, Kayla. So that's his story. So he's admitting to everything else except for the assault and the murder. But he's admitting to the other things. And he's going to trial on those. I mean, he's going to trial on all of it. But this is actually a pretty common defense strategy. You kind of admit to some stuff and you say to the jury, look, my guy admits to everything he did. He's come clean for you. He's telling you the truth, but he didn't do this. You can convict him on everything else, but he didn't do this. And you know that because he's being honest about what he did do. This is fairly common. Now, what he's saying he didn't do is the worst charges. So obviously it didn't work, but that's the situation. And the problem that's going to arise is the second-degree assault attached to the murder itself.
Before trial, Adam moved to sever the assault charge that Brett just mentioned. The court denied the motion, and this is where the problem began. This all turns on New Hampshire Rule of Criminal Procedure 20, which says, quote, unrelated charges may be joined only upon written motion of the defendant or with the defendant's written consent, and upon a showing that failure to try the charges together would constitute harassment or unduly consume the time or resources of the parties. So obviously that didn't happen here. So the question becomes, is this a related or unrelated charge? And if it were related, should it have been severed anyway under the best interest of justice rule?
So there's this whole notion in the law that typically you can commit all sorts of crimes, but you're only going to be tried at one time with crimes that are all related to each other. So you rob a store, you shoot the clerk, you steal a car, you run over a police officer, you run a stop sign, okay, and while you're fleeing. All 5 of those you can be charged with because they're all part of this one common occurrence, this one common nucleus of facts. But let's say you had a bunch of like unrelated crimes that you did. Well, you might imagine a situation where the DA's like, I got 10 charges on you. I'm going to charge you with one. We'll see how it goes. Then I'm going to charge you with another one. And then another one, and then another one, and then another one. And by the time I get done, you're going to be bankrupt, even if I can't convict you of them all. Well, you can imagine a situation where the defendant says, hey, I know these are all unrelated, but let's do them all now. I want to do them all now. Let's get this done with, right? That's sort of what the rule covers. If the charges are related, though, you can bring them, just like that robbery situation. Now, the more complicated and difficult situation is when you have a pattern of behavior. So you robbed a store in January, then you robbed a store in June, then you robbed a bank in July, then you mugged somebody in September. You know, there's all these sort of different crimes, but they're kind of related, but they didn't all happen at the same time. Can you be charged with all of them at once? Complicating this further is when you have some sort of domestic situation. So you're beating your wife, you're beating your daughter over a course of time. Eventually, you beat her to death. Are those related? Generally speaking, the courts have said, yes, they are. And in this case, even in this case, the New Hampshire Supreme Court doesn't say these are not related. Doesn't say that. It agrees. Yes, the fact that he was beating her in July is related to him beating her to death in December. But you have this best interest of justice rule. And this is kind of like Rule 403. It's kind of like Rule 404. It's this whole notion that if you have a incident which, even though related, would so inflame the jury, would so prejudice them, you shouldn't bring that in, whether it's evidence or whether it's another charge, because the jury will see that and they'll say, I hate this guy. I don't care whether he did it or not. I'm convicting him. Whether he let Kayla kill her or whether he killed her himself, I don't care, because he's a scumbag and I'm convicting him. That's what you're trying to avoid with the rule. And so the rule says you should sever a charge, even if it's related to the larger charge, in a few instances. And here's what the court said. It said courts should determine whether some charges are likely to, 1, unusually inflame the jury against the defendant. 2, the evidence in support of some of the offenses is weak, while the proof of others is strong. 3, the defendant's available defense for different crimes are inconsistent. Or the defendant wishes to testify as to one offense, but not as to others. And I think you can see how all of those are reasons not to try a bunch of different offenses together. And when you have multiple factors coming together, it counsels severing the charges and trying them separately.
So you can imagine this is all in order to give the best defense to defendants. So this is essentially a Rule 404 style analysis. You've heard us talk about 404 before. If the other charge would so inflame the jury as to not permit them to properly weigh the evidence, you should sever it. So here's how the defense put it in their brief. Because the charges involved the allegations that the defendant struck the victim with his fist at different times, places, and contexts, there was a substantial risk that a jury hearing the strength of the state's case on the July 2019 charge would draw the improper inference that he similarly struck her in December, and thus dismiss any doubt it might have had as to his guilt on the homicide charge.
So that's the argument of the defense. So you got a very inflaming charge, and there's a lot of evidence for it. Essentially, here's what you got. So on this July 2019 charge, you have multiple witnesses who saw Harmony with a black eye. You have multiple different witnesses, friends, relatives, etc., to whom Adam admitted doing it. They had multiple witnesses who said, yeah, he was proud of it. I mean, the guy was bragging about it. He's disciplining his daughter, and he's great. He said that the reason he did it was because she was supposed to be watching the baby while he used the bathroom, and he came back, and the baby's lips were blue, and he thought maybe she'd done something to the baby, and so that's why he punched her in the face. He tells this to multiple witnesses at multiple different times. They all testify to this. So the position of the defense is, that was pretty strong. You know, they kind of got us on that one, right? There's just slam dunk evidence that he abused her, and it's an inflaming charge. Slam dunk evidence he did it, and it's an inflaming charge. Compare that to the murder itself. So the primary witnesses you have for the murder itself, Kayla's in the car with him. He has conveniently accused her of doing it, which means her credibility is suspect. And she had changed her story on multiple times, and she had helped him dispose of the body. So she's tainted. She is the main witness to the murder. Now, there's all sorts of evidence that he's involved in the disposal of her body. There's DNA evidence. There's receipts when he bought the bags and the saws and all this other stuff. There's evidence of her being in these various places, including in this freezer in a restaurant where he worked. So there's lots of evidence that he's involved in the things he admitted to. But the main evidence that he is the one who killed her is Kayla's testimony. Because remember, they don't have her body. If they had her body, I think it'd be pretty obvious she was beaten to death, and that would be a huge piece of evidence against him. But the main evidence, he's the one who did it, as opposed to just the one he covered it up, is her testimony. So the defense is saying, look, lots of evidence on this first charge, not as much evidence on the second charge. So that's why you should find that this was error. Now, the state responded and said, look, the concern here, number one, this is an abuse of discretion review. The trial court gets deference. You should be giving deference to the trial court who made this decision in the first instance. And there's no risk that you have to be concerned about this because we didn't mix the evidence. We presented the evidence to the July assault. Then we moved on from that entirely different witnesses, entirely different presentation about the murder. We weren't conflating things. We weren't, for instance, asking one officer about both. So you're sort of building the officer's credibility through his very strong answers about the July assault. And then the jury is primed to believe him. They're primed to believe he knows what he's talking about, that he's very clearly telling the truth. Then you bring in the weaker case. And if his testimony is a little weaker, jury doesn't pay as much attention. They didn't do that. It's completely separate. They discussed them separately in the closing. They did one, then they moved on to the next one. The jury was instructed to consider each of these crimes and charges separately and not to let a verdict of guilty or not guilty on one influence the verdict on other charges. And it is bedrock law in every jurisdiction, including in New Hampshire, that juries are presumed to follow jury instructions. So what you have here is a presumption that the judge got it right that has to be overcome. The prosecution taking specific steps to ensure that this related charge, it's not an unrelated charge. I think that's important to remember. This related charge is presented in a way that doesn't prejudice the jury. And there's a jury instruction given by the judge to help the jury see through what is a difficult situation, but weigh these separately. And there's no indication in this case that the jury didn't do that. There's no evidence of jury tampering or the jury came out and said, I didn't care whether he killed her or not. I was going to convict him. It's none of that. What you had was a very conscientious prosecution and trial judge attempting to present all of this in a way that would stand up on appeal.
So ultimately, these are high standards, right? These are supposed to be kind of the higher standards of deference to the court. So this is largely a judgment call for the Supreme Court, but it is one in which they're supposed to defer to the trial court unless the trial court went so far as to abuse its discretion, not just kind of get it wrong, but abuse its discretion. And the Supreme Court found that the trial court had abused this discretion. Essentially, the court said that evidence of assault was so strong that any error in joining that claim was harmless as there were multiple witnesses to the event.
So the assault claim stands. So he's trying to get them both thrown out. He's going both ways. He's saying, hey, you should knock them both out because they're both influencing. Well, the Supreme Court at least said, hey, the evidence of the assault's strong, so we're not throwing that out. But when it came to the murder, the fact that the assault claim stood up on review and survived was actually a bad thing for the prosecution. The prosecution would have been better off if the Supreme Court was like, close call on assault. It's pretty close. We're going to let it stand. They'd have been better off if that were the case, which I know feels weird and wrong, but you got to think about how this test is applied. And the Supreme Court essentially said, look, the only direct witness is Kayla. She has credibility issues. They hand wave away the DNA, the receipts from Adam buying the equipment to dismember the body, and other things because they said, look, that's directly related to the things he admits to. But the thing that they do that bothers me, and really should have been enough to maintain this conviction, is Adam made statements about Harmony that indicate he's the one who killed her, that undermine this whole she did it. If you loved your daughter and then your wife murdered her, and you got to make the tough call about whether to lose your wife and your daughter, which was not a tough call for me, but I'm giving you the benefit of the doubt, lose your wife and your daughter, or lose your daughter and maybe your wife can be rehabilitated. That's one thing. But Adam told one friend after this happened that he hated Harmony to his core. Hated her to his core. And he told another friend that he'd gotten angry and effed up, quote unquote, effed up. To me, that should have been enough. I want you guys to all pay attention to this case for one very important reason. Since we have started this podcast, there have been people who have constantly said it is too difficult to overturn a conviction, who think that, defendants, they don't have any ability to appeal and it should be easier to overturn a conviction and all this other stuff. And we argue to you all the time about finality and why finality is important and why we don't just retry cases willy-nilly. Harmony has a brother, and her parents now who've adopted him gave a statement to the police and talked about how now he's going to have to go through this again for this obviously guilty person. And that's important because that's part of the standard. This obviously guilty person who had overwhelming evidence against him, whose only claim is a self-serving claim that someone else did it, who was directly involved in dismembering her body, in burying her body somewhere. And oh, by the way, won't tell him where the body was because of obvious reasons. And the New Hampshire Supreme Court had all of that and decided to exercise its discretion to vacate this conviction. And now the state's going to have to charge it again, which they said they're going to do. And this is why it is so important that courts act in reserved ways and actually apply the law as it is written to make these decisions. Because when they don't, you end up in situations like this.
Those are some bad statements.
I mean,
those are some bad statements. It is really amazing when I feel like courts divorce the facts from, facts do matter. And I understand appellate courts are supposed to go off the record. And it's supposed to be this cold, hard record. But these statements are incredibly damning, and they're from his own mouth, and paired with all of his own admissions are, I would think, enough to let the murder charge stand. I'm glad that he's still sentenced to the 43 and a half years, but justice still matters in terms of who ended Harmony's life. It was not Kayla. He took responsibility for a lot of things, but all in part of a larger grand lie in his defense, because he's the magnanimous husband covering for his wife. But this is, sometimes these appellate court opinions are hard to swallow.
And look, obviously, there's the emotional side that you want this conviction to stand because it's horrible. But I think everyone needs to understand that there's a standard here. And the standard is not, the judge, we would have done it differently. Now, we Supreme Court justices, if I had been on the bench that day, I would have severed them. That's not the standard. The standard is the judge gets deference. Only if he abuses his discretion do you overturn him. And I think this is also important because I feel like people have missed this in the reporting. It's been reported as if they charged him with this unrelated assault that happened a long time before. It's completely unrelated, and they just did that to put their thumb on the scale and make it easier to convict him of the murder. Even the New Hampshire Supreme Court doesn't say it's an unrelated charge. So if it were an unrelated charge, at least that's a better argument to say the judge abused their discretion. But it's a related charge, and you're having to go to this essentially safe harbor provision that says even if it's a related charge, in extreme circumstances, you should still sever it. So you've got a trial court judge should only do it in extreme circumstances. The trial court judge heard the claim and denied it. They get deference on this extreme circumstance decision they made. As an appellate court, they are just so obviously wrong that no one could disagree. Unless it's that bad, you shouldn't be reversing. But it's even worse than that, because even if you decide that the judge abused their discretion, that's still not it. You still look to see whether or not the rest of the evidence was strong enough to overcome whatever prejudice there was by the joined charge. And the simple fact of the matter is, with or without the assault, he would have been convicted. There's enough evidence to convict him. There's his statements. There's the fact that he beat her would still come in. It's related stuff. And in fact, the Supreme Court of New Hampshire does the same thing that South Carolina did in Murdaugh. Goes ahead and rules on all the other stuff. It is like, but since this will come up on remand, we're going to go ahead and talk about all these other challenges to the evidence and rules against him on all these challenges. So all this stuff was still going to come in that came in the first trial. And that's why they're wrong. They're not wrong because they let a bad guy off. That's not why they're wrong. They're wrong because they had a standard and they didn't apply it. You hear the term judicial activism. Judicial activism is when you have a standard, but instead of applying it, you put yourself in the position of the judge and you say, well, I would have done X, so that's what we're going to say. And that's why, look, these state courts are really important, and all of you out there need to care about state courts and how they're appointed. The New Hampshire Supreme Court is appointed by the governor, and you need to hold the governor accountable. I don't know who appointed these people, but you need to hold the governor accountable. If you're in New Hampshire, hold the gubernatorial candidates accountable for what kind of judges they're going to put on the bench, because those people make these decisions. And it's just fortunate that he was convicted of the other things, or else he might be out on the streets at this point. So I don't know.
Had it not been for that,
wrong.
that would have been a travesty. This still is a travesty to me, but
no,
I don't have much more to say just because it's so incredibly sad. This 5-year-old girl, I mean, look at sweet Harmony's face. She is a small, small child. No child deserves to be beat. Certainly not a 5-year-old child who is a fraction of his size for something like, having potty accidents, which is commonly known to happen when there are stressful instances like being homeless or, I don't know, being beat so hard that something in your face cracks.
I mean, take some responsibility for yourself. Take some responsibility for what's happening to your daughter. Like, this is your fault. All of this was your fault. It's not her fault. It's your fault. And even if you're just legitimately down on your luck and things have gone against you, which happens, there are resources available for your daughter. She has a mother who I'm sure you hate, so you don't want to reward her with the girl. But
he had parents.
He's obviously a terrible person. Yeah, he had parents.
They had extended family that they were living with. I mean,
he's
probably burned all those bridges.
That he hit her. Yep. An uncle who told that he punched her. I mean, half the people who testified against him were in his family.
Right. So, there were extended family members. There were strangers who would have wanted to take her in. Exactly.
Anyone would have taken her in. So you should be angry about this, not just because he got out, but because the New Hampshire Supreme Court got this wrong. Like the South Carolina thing with Murdaugh, I get it. I get why they did what they did. I'm not sure they got it exactly right, but I totally understand. I mean, Miss Becky, Becky, I get it. This is
this
trash.
one I don't get. This just I don't get. Yeah. This I think is just incorrect.
All right, so we're going to move on from that.
Speaking of other monsters.
Yes, let's continue down the monster trail. If you missed it, Rex Heuermann.
Howerman?
Howerman.
Oh, I thought it was Howerman. But
I don't care.
I don't know.
Screw him.
Serial killer. Who cares how you say it? I'd like to say his name wrong.
Yeah. He was sentenced today. No surprise. He got life without parole. It's been the rest
If you
of his
remember,
life
he pled guilty
prison.
back in April. If those of you who are waiting for a trial, it never happened because, the evidence was so overwhelming over him that he pled guilty to 8 women, 7 that they found. There was an 8th one that was part of the plea agreement. But I guess we have that going for him because unlike Harmony's father, Adam never admitted to anything. At least Rex pled guilty.
Yeah, at least Rex pled guilty. Now, as always happens, people always think somebody's going to plead guilty and then we're going to get lots of answers about why they did it and everything else. He, of course, didn't do that. His statement was basically, it doesn't matter. Whatever I said wouldn't matter, so I'm not going to give a statement. Judge was really harsh on him, which is good. Definitely someone who in the good old days would have gotten the death penalty, but instead he'll live his life, doing the whole Mindhunter thing with the Bureau. He's part of his plea agreement was he has to do interviews with the behavioral analysis unit, talking about why he did what he did. I'm sure he's going to love that. Probably write a book. Who knows what he'll do. That's the problem. And this just goes back. Everybody wants prison to be awful. Prison is not that bad. It's not great. I wouldn't want to be in prison, but it's not as bad as you think it is.
It's not as bad as his life should be.
Right. Exactly.
Honestly. Honestly, the way Adam was living,
prison's probably an improvement.
It probably is. He gets 3 square meals a day. He probably wasn't getting that when he was living in his car.
Yeah. So, anyways, these monsters, they go away, live the rest of their life in prison, so be it. But nevertheless, at least he is spending the rest of his life in prison. At least there
can't do this again.
Justice for the people who he murdered. And, he's a big guy, so maybe prison will be really uncomfortable for him because he's so big. You can say that. All right, so we're just running through some things that happened. So the next one, I'm curious what you think about this, Alex. I'm not sure if you saw this. So back in the 70s, the Supreme Court said that for non-capital cases, criminal cases, states can decide how big a jury is going to be. And so a lot of states have smaller juries for non-capital cases. They'll have 6 or 8, 10. They just have fewer than 12. We've actually seen that in some of the cases we covered. I'm always surprised whenever I see it. I'm like, what do you mean? What do you mean they pick 6 and it's done, right? Anyways, well, the Supreme Court has granted cert on a challenge to the jury being less than 6 people. They have been asked to overturn their earlier decision about this, and they've granted cert. Do you have any thoughts on that? Initial thoughts? We'll probably look
So
into
it's
it more
just on
later.
under 6?
Under 12.
Oh, under 12. Okay. Oh, that's interesting. I mean, obviously, if they're granting cert on this question, reading the tea leaves, you imagine that there are at least, 4? Potentially
Yeah, they gotta
5.
have 4.
They have to have 4, but if you are going to grant, cert on the question, you want to be able to do what you want to do. So you think that you have an inkling that you can get to 5 at least to do something about it. Because usually you don't take a case, especially at the Supreme Court. We've said this before, 70 to 80 are granted cert a year of the tens of thousands of cases, 70, 80,000 that are filed. So you typically don't just get a case to say, affirm what we previously said. Jury of 12 for capital cases, everything else is fine. So the idea behind this is court watchers are saying, are they doing this because they want to overturn it?
And so my problem with this is pretty simple. The Supreme Court is lazy. They don't do enough work. They need to take more cases. But by goodness, if they're not going to take more cases and if they're going to continue to be lazy, don't waste your time with this. This is a waste of time. This is not a big deal. Whatever originalist opinion Gorsuch is eventually going to write, talking about how in 1100, immediately after the Magna Carta, the Bishop of Edinburgh said that the mystical number of 12 is what is required in order to have a fair trial, is completely irrelevant. And there are so many cases that they don't take with issues that actually matter, that are affecting people's lives, that it always drives me crazy when they take cases like this. And I also don't know. I mean, I haven't read any of the briefs or anything, but so obviously you have to have a jury of your peers, and jury has to be more than one person. It has to be multiple. It has to be peers, multiple people. But why is 12? Okay, so let's say that the Bishop of Edinburgh did say it was 12, and it was 12 at the time of the founding. The Bishop of Edinburgh probably also said it needs to be educated men who are landed because they have an interest. I mean, they call them peers for a reason, and it's not because they're your friends and family. Initially, that was the idea. The nobility was judged by the nobility. They're peers, right? So why is the number sacred and inherent to our Constitution, but not the makeup, the qualifications, various other things? They also didn't allow felons to be jurors. We allow states to waive that. There are many states where you can be a juror, even if you're a felon. Should the Supreme Court say that that's inherent to this Constitution too? What if a state wanted to make it 14? Could they do that? Because presumably the argument is not you need 12 for due process. Like the only way you can have due process
at least
is 12.
But do you not have due process if it's like 28? Like a really big number?
If the Bishop of Edinburgh said that 12 is the mystical number, then why is 14 constitutional? The mystical number is 12. It has to be 12.
Because of the apostles, Brett.
I mean, that's the thing. Is that why we're going to do this? We're going to say that the Constitution requires states to have a
I'm not going to say that I thought this
jury?
much about it before we recorded, but now you have me inflamed about this.
And I tell you what else I don't like about this is the kind of case, it's going to be so silly and stupid that it makes looking back to what was going on at the founding, originalism, looking to the English common law, it makes all that look silly because you're doing this silly, how many angels can dance on the head of the pen historical analysis. You're doing basically the thing people always criticize you for doing. So I'm irritated by the whole thing.
That's a fair point. I didn't have any thoughts about that before we started talking about it tonight, but now I understand the fury.
I probably wouldn't be so inflamed by this where we're not talking about the Adam Montgomery thing, but I'm already in a mad, angry mood.
That's fair. And you got showered, and so now you're like,
Exactly.
you're clean, and you're just angry. You're looking to pick a fight.
Just mad at the world.
I am mad about the Adam Montgomery things. Okay, so I understand your anger overflowing to the jury of 12. I was like, I don't know where this is going, Brett. I'm not that angry about it. But now I understand the anger.
We'll see what happens. I'll say this. So about 7 or 8 years ago, the Supreme Court granted cert on the dual sovereignty prosecution. So prosecuting the state, prosecuting the federal. They granted cert on that, and everybody assumed they granted it to overturn prior precedent that said you can do that. And we all know who led the charge on that. And that justice ended up being in the minority and writing an opinion on why they should have overturned it, but they didn't. So my hope is a similar thing will happen here. We'll get a 6-3 opinion or a 5-4 opinion with states being able to decide for themselves what number is sufficient to satisfy due process on a jury and not enshrining the number 12 because there's a movie. I guarantee you, if they overturn this, Justice Gorsuch will write the opinion.
He probably would, actually.
I like Justice Gorsuch, not being critical, but he'll write the opinion, and he will absolutely cite 12 Angry Men when he does it.
He probably would open with a line from it.
He probably will. Last thing, Substack.
The most exciting
some of you guys read
update.
Substack, True Crime Times. I know Alice is a follower. She reads it every morning over her cup of coffee. So there you go. So we are adding a feature to it where these videos will be on the Substack for subscribers. So as we've often said, there are multiple ways to see us. You can do the $3 on Patreon. You can watch us record these. You can get Apple if you hate Patreon, but you can't see the videos through Apple, at least right now. We may do something with that later. So we wanted to give people who want to subscribe but hate. This is really our crusade to make it where you don't have to use Patreon.
I know.
So this is the way. If you want to watch these, but you don't want to do Patreon, we're going to have that option through Substack very soon. True Crime Times. If you just Google Prosecutors, True Crime Times, it'll come up and you'll be able to watch these videos. They will be unedited. So you're getting the just pure Prosecutors experience that people on Patreon have been glorying in for the last few years. I have no idea what it is. Somebody just asked how much the Substack is. I don't even know.
I don't know either. I'm not totally even sure how to use Substack. I can log in.
And the great thing about Substack is we have, there's a lot of, it's not just us. So there's a lot of articles on there, contributions by victims, by advocates, by people in the law, scholars, all sorts of other things. I just spoke to somebody who's going to write something for us I'm very excited about. So we'll see that soon. But there you go. That's another option for those of you who want to support the podcast in that way.
And I'll say this. I know some of you, if you were like me, my screen has gone dark, but I hope you can see me, are like, what I've been surprised at, I'm like, why do we need more avenues to reach us? But as Brett commonly reminds me, I listen on YouTube Music. And so I never go to Spotify. That's just me. I know everybody else listens on Spotify. But because of that, we have found that people really do want to stick with their platform, and they're happy when we make it available on a different platform. Prove me wrong.
The Apple thing blew me away.
Apple thing blew me away. I'm sorry. I'm just trying to turn my screen on. I can't see anything. But
we can see you. So that was a nice adventure there. So the Apple thing, I was very surprised by. I didn't think people would subscribe.
So many people,
subscribe to Apple?
And not people who left Patreon to go, as far as we can tell.
Yeah, it's totally different people.
Because they were never liked Patreon, understandably, and just were waiting for us to go over to Apple, I guess.
Yeah, and they came in droves. So thank you to all of you.
Thank you so much.
Who did
Truly,
that.
thank you.
All right, that's all I got.
What a day. What a day. And we've recorded 3 days in a row that Brett actually had to shower to show up for today's recording. But guys, let us know what you think. As always, especially on legal briefs, you guys get to set the agenda. If there's something or some case that has happened in the news you want us to talk about, send us an email at prosecutorspod@gmail.com. Let us know. And we would love to continue this discussion on The Gallery, our fan-run Facebook group with some of the best discussions in true crime. Before we sign off for the day, Brett, do you have any showering tips for people?
At least once a week, guys. At least once a week.
I'm going to go more than once. But with that, guys, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. So I can't see anything. This is very disconcerting to me, but I hope you can see me. Well,
Is your whole screen black?
Remember, this has happened a couple times. It's like a static charge thing. I've looked it up before.
I need to get on this, fixing it.
I don't understand. This has happened. Yeah, it's like everything's still working, but the screen is just black, but it's like a little bit backlit, so I know it's not off. Does that make sense? Like,
wild.
I know, it is wild. Anyways, I'll figure it out.
Okay.
This was such a sad case.
Oh, God. I know. They all are. Just terrible people doing terrible things.
Hello, and welcome to Pluto Phone. If you know the name of the movie you'd like to see, just stream it for free on Pluto TV, where all your blockbuster favorites are landing all summer long. Catch Anchorman, The Legend of Ron Burgundy.
Fantastic.
The Matrix Trilogy.
Welcome to the real world.
Mean Girls.
Shut up!
Titanic.
I'm the king of the world.
And so much more. For showtimes, press nothing. They're free 24/7.
That is so fetch.
On Pluto TV. Stream now, pay never.